Now for brief biographies of our panelists. Diane Macdonald has been practicing labor law since 1995, first in private practice and then with the BC Teachers Federation, where she's currently in the position of General Counsel. Diane has acted as legal counsel before arbitrators, various administrative tribunals, and in court. She acted as counsel on 2 successful cases before the Supreme Court of Canada, a 2014 charter case, Section 15 charter case regarding pregnancy and parental benefits, and a 2016 case regarding the duty to consult under Section 2D of the Charter, which of course is directly on our topic today. Diane received a BA from Simon Fraser, an LLB from Dalhousie Law School, and a PhD from Northeastern University. Her PhD dissertation focused on collective bargaining structures. Bruce Archibald is a native of Nova Scotia, educated at the University of King's College, Dalhousie University, Columbia University, and University of Paris 1. He has been at Dalhousie Law School, now Schulich School of Law, since 1976 in a variety of subject areas, including criminal law, criminal procedure, evidence, etc., and including labor and employment law. He has served as a consultant to federal and provincial governments and to law reform and public royal commissions. He's arbitrated in the public and private sectors. He was part-time chair of the Nova Scotia Labour Board and has served as part-time member of the Canada Public Service Labour Relations Board. In his off hours, Professor Archibald is a sailor, singer, and bluegrass banjo player. We'll start with Bruce, then go to Diane, and then back to both of them again. Bruce.
Okay, well, look, it's a real pleasure to be here and a privilege to talk to people who have varying roles in the labor relations community. My first segment here, we agreed to have me do a kind of general overview for 10 minutes of the constitutional cases which we're now dealing with. And then after we hear from Diane, I'll come back and talk a little bit about what's happened specifically in teachers' collective bargaining in the province of Nova Scotia. So look, in terms of the Charter and its impact on labor relations, as you're all aware, back in the late 80s and into the 90s, there was the old labor law trilogy plus one, where it was said that Section 2D of the Charter dealing with freedom of association does not encompass collective bargaining or indeed the right to strike. Therefore, we've been shut out from a legal perspective in terms of dealing with constitutionalized collective bargaining and so on. That began to change in around 2000, where there was this case called Dunmore, where, interestingly enough, it was Justice Bastarache, a guy who was familiar with collective rights, really, in his book on language rights, said that we could make an exception for very vulnerable people, agricultural workers in Ontario, and that they should have a right to bargain collectively. The Ontario government responded with some legislation, but meanwhile, it had been said that RCMP officers are not vulnerable people, and they need not have a right to bargain collectively or a right to a union. That was the state of the play, as you're probably mostly aware, until 2007, when the Supreme Court of Canada got so annoyed with what had happened in British Columbia in the health sector in terms of rolling back collective bargaining, dealing with interfering in collective bargaining in the public sector to such a degree that they overturned the early trilogy, said that indeed the Supreme Court had been wrong in the mid and late 80s, and that freedom of association indeed encompasses collective bargaining, and that the kinds of things that the British Columbia government had done without consultation with the unions in question had breached the right to freedom of association, which now encompassed collective bargaining and was not saved under Section 1 of the Charter. This was a huge reversal based on a historical analysis, based on international labor rights. And indeed, it was the dissent of Mr. Justice Dixon in the trilogy cases, which was revived in important ways in the BC Health Services case. People began to wonder what this really involved. It was said, of course, in the BC Health Services case that what you have a right to is a process and not an outcome. So substantial conditions you don't have a right to, but a right to a fair process in collective bargaining was what was said you needed. Then back in, there was a round which we need not really talk about, the Fraser case out of Ontario, a second round on the agricultural workers. The legislation which had been set up was found to be insufficient, but the Supreme Court of Canada, in curious ways, said it should be interpreted in ways that respect collective bargaining. That was a pretty broad and sweeping kind of purposive interpretation of the legislation, which was quite curious in many ways. That's the state of the play until 2015. In 2015, there were two cases in February. One, Mounted Police Association of Ontario, where the Supreme Court of Canada said that the system which the government had set up to allow for, in the RCMP Act, to allow a process of consultation which was essentially controlled by the employer, was insufficient, and that collective bargaining needs to have unions which can be chosen by employees as their bargaining agent, and who act independently in that process of collective bargaining, and that the system established by the government in relation to consulting with the employees was insufficient. So this is an important case in that it establishes that unions have to be independent, have to be chosen by their members. But once again, the court was saying we're not constitutionalizing the Wagner Act model, and that nonetheless, the system was unconstitutional, could not be saved by Section 1. On the same day, there was a case called Meredith decided, which is very important, but I want to set it aside for a moment to talk about the Saskatchewan Federation of Labor case. That case was decided a month later in March, and as you're probably all aware, the designated essential services bargaining model in Saskatchewan, which was very much controlled by the government, was found to be unconstitutional because it took away the right to strike and did not replace it with a mechanism of interest arbitration or an adequately independent emergency services kind of model. So that was a big change. Back in the BC Health Services case, the Supreme Court had said, look, we're not talking about the right to strike. we're not saying whether there is a constitutionalized right to strike. In the Saskatchewan Federation of Labor case, the court said, yes, there is a constitutional right to strike. But of course, it's subject to Section 1 proportional limitations. And the court held that the absence of interest arbitration or a dispute resolution model which would respect the independence and the choice of employees and collective bargaining as reflected in the Mounted Police Association of Ontario case meant that the Saskatchewan legislation was held to be unconstitutional, did not survive Section 1 limitations, and set a precedent which has had an impact, I think, internationally.
Bruce, I'm just going to give you another minute or two for this round.
Okay. All right. I thought I was within my time frame since your introduction was fulsome and delightful, of course, Larry. But at any rate, just let me talk about Meredith, because it seems to me that in the public eye and in trade union circles, the emphasis is put on the Mounted Police Association of Ontario case, which said unions have to be independent, they have to be based on the choice of the membership, and that the right to strike was recognized. On the same day that the Mounted Police of Ontario case was decided, there was a case called Meredith. Meredith has not received much public acknowledgement, but certainly government and employer counsel are very much aware of it, because in Meredith, RCMP officers challenged the Federal Expenditure Restraint Act, which limited the negotiations which they had done through their bargaining pay council, which had been found to be unconstitutional in MPAO. But at any rate, the Supreme Court said, well, we just declared your system to be unconstitutional, but in fact, they were consulting with you, the government. The Expenditure Restraint Act applied across the board to civil servants, and it was not a limitation. It was not unconstitutional to enact legislation which put substantive limits on the deal, if you want to put it that way. And of course, this goes back to the health services case, which says you have a right to a process and not a right to an outcome. The government was said to be acting constitutionally when it legislated an outcome because there had been in the minds of the majority of the court an adequate consultation process, but even Rosie Abella, who dissented on the grounds not that the government was wrong to impose wage restraint, but that it had not adequately consulted. So there's this tension now between the Saskatchewan Federation of Labor case and the MPAO case, and this case of Meredith, which certainly applies in the public sector. What its impact on the private sector might be is a matter of interest and speculation. Sorry to go over time a bit there.
Okay, I'll jump in here, and thanks for that great overview. I'm going to talk about the teacher's case in British Columbia, and I'm going to start by giving a background to what was a very lengthy and complicated history that took us, well, 15 years to finally get a remedy. But it all began in 2002 when the government imposed legislation on teachers that deleted numerous significant collective agreement terms that dealt with teachers' fundamental working conditions, and they were specifically dealing with issues such as class size, class composition, which is how many special needs students can be in the classroom and what sort of supports teachers will get to assist with students who have been designated, student-teacher ratios, non-enrolling teachers, etc. So those types of provisions. And in addition to removing all of these provisions, the government, the legislation said that you couldn't bargain those types of provisions in the future. And in the legislation, the government had set up a process to appoint an arbitrator to work with the parties to remove those provisions from the collective agreement. The arbitrator was eventually appointed. There were a number of arbitrators that didn't want the appointment and declined, but eventually the government appointed an arbitrator who removed hundreds of provisions from the collective agreement and didn't do it in a very sort of surgical way, but anything that touched upon those issues was removed. So the teachers judicially reviewed that decision and won. The court, BC Supreme Court, said that there had been fundamental legal errors, but instead of appealing that decision when the government disagreed with it, they just imposed more legislation to impose the arbitrator's original decision. So that got wrapped into the constitutional challenge because the teachers had challenged the original legislation in 2002. Now they added the legislation from 2004 that was imposing the arbitrator's award, and that challenge was held in abeyance while the health services case was going through the courts, because of course that came out of BC too. With healthcare workers and others, which had been legislated at the same time as teachers. So once the health services case came down and they had won, and now that collective bargaining was part of was protected by Section 2D, we went forward with the constitutional challenge that we had, and we argued the case in 2010 before Justice Griffin at the BC Supreme Court. And when we got to court, the government's main arguments about why this was not a violation of Section 2D and why it was different than what had happened in health services is they were saying that these types of provisions, class size, composition, etc., weren't traditional collective bargaining terms, but were in fact matters of public policy and shouldn't be bargained. And they also said that the provisions lacked flexibility and they weren't workable. Well, the trial judge ruled against them. On the public policy issue, she said, sure, it's matters of public policy, but they're also fundamental working conditions for teachers, and we'd called a lot of evidence on that. And she also found that the provisions didn't lack the flexibility that the government was saying. In fact, there had been built-in flexibility in the collective agreement language. And she found that the government's position was based on hearsay and myth, that the clauses were inflexible. And she said it was kind of ironic that they had put these clauses into legislation which was inflexible. They didn't have flex factors and provisions for if there were special circumstances, etc. So she ruled against them, and following the decision in health services found that there was a substantial interference with Section 2D of the Charter. And so she struck down the legislation. This is in 2011, but she stayed the declaration of invalidity for a period of 12 months, as it happened in health services, for allowing the government the time to address the repercussions of the decision. So surprisingly, the government did not appeal that decision. And it came to light that the reason they didn't appeal it was because of some comments made in health services and in the teacher's case, that they believed that their only constitutional error was the fact that they didn't consult prior to passing the legislation. So they thought that that was their mistake. So instead of, and that was based on some statements in health services. It's a two-part test that talks about the first inquiry is into the importance of the matter being bargained, and the second inquiry is into the manner in which a measure impacts upon collective bargaining, or the manner in which the legislation was imposed. And from that, they understood that had they consulted, then they would have satisfied that second part of the test. So instead of appealing the decision, they engaged teachers in a consultative process. And that process happened, it started in 2011, May of 2011, and it broke down in November. And what happened during those consultations, in a nutshell, is that despite losing the case from the 2002 legislation, the government came in with the same position. It was still saying these are kind of public policy matters, although they weren't pushing that as much, but they were certainly pushing that the provisions were inflexible and they weren't prepared to have them in a collective agreement. So as a result, the consultations were not successful, and following the impasse in the consultations, the government imposed more legislation in 2012, passing very similar legislation. So in that piece of legislation, they repeal all of the provisions from the 2002 legislation, and then they put them back in as of 2012. So they've satisfied the first decision by removing them, and then they put them back in. This is in the same piece of legislation. There were two key differences. Otherwise, the legislation was identical. First of all, the government in the legislation said that the teachers could, or the parties could, negotiate about those subject matters, class size and composition, etc., but not this round of bargaining, not immediately, but in the subsequent round of collective bargaining, because teachers were in the middle of bargaining at that time. And the other difference, as the government argued, was that they had consulted prior to passing the legislation. There were some other minor differences, but those were the main differences according to the government. So we ended up in 2014 back again, and teachers challenged the legislation. We ended up back in front of Madam Justice Griffin, the trial judge in the first case, and she dismissed their consultation argument, and but said if she was wrong on that if it was relevant to Section 2D, then they hadn't consulted in good faith. And so she said that for the same reasons that she had ruled in 2011, that the provisions were a substantial interference with collective bargaining and they weren't saved by Section 1. And she restored the deleted clauses back into the collective agreement.
Diane, a minute or two?
Back to 2002. Okay, I'll be really fast. Fast forward, we end up in front of the Court of Appeal because we challenged, they challenged that decision, and we lost at the Court of Appeal. Court of Appeal said that consultations were relevant and that they were not, that they were conducted in good faith, and they had a sort of new test for good faith bargaining, which I'll talk about in a second. We then, we were quite surprised by that decision. We sought leave and were granted leave to the Supreme Court of Canada. The case ended up in front of the Supreme Court of Canada in November of 2016, and we got, in a sort of surprise turn of events after oral argument, the court took a short recess and came back and gave us a ruling from the bench in our favor. The ruling said that a majority of the court expressed substantial agreement with the reasoning of the dissenting judge at the Court of Appeal, because there had been a strong dissent. And so now we're in a situation where the dissent from the BC Court of Appeal is now the majority judgment at the BC Supreme Court, or sorry, the Supreme Court of Canada. So I'm just going to highlight two things that the dissenting judge said. First of all, he agreed with the majority and the province that consultations can be relevant, but he had a number of situations that were number of sort of factors that you had to meet before you could rely on consultations. And I'll talk about that in my next 10 minutes thing, because I'm not going to have time here. But he also talked, and this is, we won on the issue of good faith bargaining, because he found even though the consultations were relevant, they were not conducted in good faith. So he relied on the trial judge's reasoning for this. And he, first of all, criticized the test that the majority of the Court of Appeal had applied. They had said that the courts do not have the institutional competence to carefully scrutinize the positions and proposals of government or the parties. And he said that they were adding a new requirement to the good faith test that had been selectively culled from labor tribunal decisions, and that was incompatible with a constitutional test. And he had found that that allowed the majority at the Court of Appeal to disregard large portions of the trial judge's factual findings and allowed them to say that the consultations were in good faith. And he said the test was straight out of Health Services and Fraser, that it is necessary for the courts to monitor government action, to militate, these are his words, against power imbalances. And he found that the trial judge was correct to closely scrutinize the consultations to make sure that they were not, that the parties were not inflexible and intransigent, and that they had honestly tried to find a middle ground. And he found that, as the trial judge had, that because the government had come into the consultations with its mind made up, that it didn't want the collective agreement language back in the collective, the deleted terms back in the collective agreement, that there was no good faith negotiations. And he also found, as had the trial judge, that the government had failed to consider the teachers' positions and proposals during the consultation process. So as a result, he found, as had the trial judge, that the consultations were not in good faith, and therefore there was a breach of Section 2D. And he restored the collective agreement terms as a remedy back into the collective agreement, but on a go-forward basis, so not back to 2002 as the trial judge had done. So that's it in a nutshell, and so now, of course, the teachers have those provisions back in the collective agreement. Thanks. Okay,
thank you, Diane. We're going to go back to Bruce in a moment, but I'm going to ask the two of you, just so that we don't eat up our question time, to just be a little shorter than we had arranged to begin with. So you were going to have 10 minutes. If you can make it shorter, that's great, because we do want to have some back and forth with the audience, and you'll get a chance to answer them, I hope, as well. Thanks. Bruce.
Okay, so I just want to talk a bit about, excuse me, the teachers' collective bargaining situation. To do that, you have to go back to 2015, when in December, the province of Nova Scotia, the government, announced that it had a fiscal and financial plan, and that 75,000 public sector employees, including teachers, were going to have no increases for the first 2 years, 1% in the third year, and a 2% increase in the fourth year, and that this was all announced in something called the Public Services Sustainability 2015 Act. That legislation would set up a Public Services Sustainability Board, which could determine whether there were savings in collective bargaining processes which could allow for, in certain contexts, for the wage numbers to be adjusted, right? This piece of legislation indicated that arbitrators, interest arbitrators, presumably they had in mind, have no constitutional authority to declare that the legislation is unconstitutional. The interesting thing about this piece of legislation is that it remains unproclaimed, a kind of sword of Damocles hanging over the public sector collective bargaining. The deal was imposed on non-union public servants. Deals were struck with prosecutors, doctors, some others, but not with the main civil service unions, including the Nova Scotia General and Government Employees Union, NSGEU, and the teachers. So in terms of the teachers, the last collective agreement was negotiated in 2013. Tentative agreements were reached between the government negotiators and the union negotiators, the teachers union, in November of 2015, September of 2016. Those agreements were rejected by the membership. The wages were the government's wage deal, and the main issues were about classroom situations, the inclusive classroom, bureaucratic requirements being imposed on teachers, and so on. So as a result of no movement in negotiation on the part of the government, teachers declared a work to rule on December 5th of 2016. That ran through into January, and by February the government had indicated that it was passing the Teachers Professional Agreement and Classroom Improvement 2017 Act, which in fact got royal assent on February 21st. It imposes the 0, 0, 1, and 2 salary deal, sets up a commission of 3 people to investigate and report in a year on the inclusive classroom problem, the mainstreaming of people with disabilities, the lack of teaching assistants, and it also, in the preamble, talked about a council to improve classroom conditions, which had been agreed upon in part of the process of collective bargaining. As a schedule to the Act, the government imposed the essence of the first collective agreement, the one which had been agreed to between the negotiators back in November 2015 with some differences. So once again, arbitrators can't interfere with this, and there's, from a lawyer's point of view, it's interesting, there's a long preamble, a full page, setting out factual circumstances and arguments which will be used in relation to constitutional litigation. This piece of legislation has not been challenged. Obviously, the counsel in the Department of Justice and the Legislative Counsel's Office are aware of Meredith, and the question will be whether the kind of Meredith notion, the argument we talked about, that the substantive deal can be imposed, and that here there was not just consultation, but long collective bargaining agreements, tentative agreements that got rejected by the membership, is that sufficient to meet the conditions set forth by Meredith and undermine what many people see as the general propositions from the Mounted Police of Ontario case and the whole question of the Saskatchewan Federation of Labour So what does Saskatchewan Federation of Labor have to say about back to work legislation, the kind of thing which Canadian legislatures have done for years, right? So anyway, I'm sure questions can be directed to that.
And
So-
Bruce, I was just going to add, the legislation hasn't been challenged yet, but we do expect the teachers union to challenge it, but we don't know.
We don't know. It's fascinating, right? It's really, they're on the horns of a dilemma, you know, just in terms of tactics, strategies, whatever.
Yeah. Diane.
Okay, I'm just going to go back to, because these cases are really raising the issue of consultations and to what extent can a government rely on consultations prior to legislating? Because obviously in the teacher's case, the Supreme Court of Canada endorsed the decision of the dissent who said that pre-legislative consultations can be relevant at the first stage under Section 2D of the Charter. We had always argued that it was relevant under Section 1, but they were saying it's relevant at the first stage. But he did go on to say that to rely on consultations, you had to give the union an opportunity to meaningfully influence the changes that were going to be made on terms of approximate equality. And of course, he was relying on Justice Abella from the Saskatchewan Federation of Labor when he talked about approximate equality, and also mounted police, which really talked about the dominant purpose of Section 2D is to redress the inherent lack of bargaining power of employees vis-a-vis their employers. So, and Justice Abella said that the right to strike is essential to maintain approximate equality. So the real question is, to what extent, and I think this is still outstanding, can consultations replace collective bargaining when it doesn't have the mechanism at impasse of the right to strike or another, arbitration, interest arbitration. So that is the question. And also, Justice Donald had said that if a government permanently prohibits collective bargaining or associational activities, that you couldn't, no amount of consultation, he said, could save the legislation. So that's sort of the background. But I agree with Professor Archibald that we do have this Meredith outstanding, and Meredith did a couple of things. One, it talked about consultation, and it also did allow for the, it's not just about the process anymore, because Meredith very much talked about the outcome and really talked about how the legislation was temporary, but that it had been consistent with other settlements. So it looked at the outcome of the deal. And so we now are not just dealing with collective bargaining, as Professor Archibald said, that it was a limited process. That's what came out of sort of health services and Fraser, that it was limited to the process of collective bargaining, not the outcome or the fruits of the process. But now we do have this being mixed in, and it's because it's very difficult to divorce process from substance. That's just almost impossible, and I think these cases are showing that. There has been another case in Ontario, the Bill 115 case, the Putting Students First, which, like Nova Scotia, the teachers were bargaining under the threat of legislation. So it was, and there the Superior Court found that the consultations or the negotiations were not voluntary, and that the government had, by unilaterally setting the parameters, had limited the substance of negotiations. And like the teacher's case in BC, that the government had a desire to reach a particular end that had already been defined at the outset. And in that case, the court found that there was a breach of Section 2D. And as I understand it, there's been some settlements. There were a number of unions involved in that. So there was no appeal of that decision. So that's another case that has dealt with these issues. And of course, in following Meredith, we have Gordon coming out of Ontario and the dockyard workers in BC, where the courts have said if the legislation, if the restrictions are temporary and quite targeted, and that the outcomes sort of mimic what other unions might have negotiated or did negotiate, then the temporary wage rollback does not undermine the essential integrity of collective bargaining. So we've got these two differences. That the purpose of Section 2D is to have a charter protected balance between employers and employee, which is attained or maintained by the right to strike. You've got that on the one hand, and then you've got these cases on the other. And where the courts will strike that balance down the road is anyone's guess. So I think those are my comments. I tried to cut it down quite a bit.
Okay, thank you two. That was wonderful. On a very complicated topic, I assume that most of our participants, although they may not be labor lawyers, are familiar with these issues. So I'm going to ask you, I'm just going to repeat here what I need you to do. Let's see here. We're going to have our question period, and you're all presently muted. When the question period begins right now, you go to Go to Webinar, the menu, which is in the upper right portion of your screen, and you click the button that indicates you want to speak. When you do that, I will see a raised hand, which I don't see any right now, but I have a couple of questions just in case we don't get any right to start. And I'll identify the person I'm unmuting and invite you to ask your question. So waiting for some responses from the audience, from the participants, I'm going to ask a question. The Nova Scotia situation, I think, represents a couple more steps along the road on this whole question of what constitutes significant or substantive or meaningful consultation with the union. I suspect that the government, when and if this comes before the courts, will be arguing that they sat down with the teachers' union not once, not twice, but 3 times, reached an agreement, a tentative agreement, which was recommended not only by the negotiating committee but by the teachers' union executive, and that is evidence of substantive consultation. The fact that the union members rejected these 3 agreements, then the question is, okay, were these meaningful consultations, or the fact that the members turned them down renders them unmeaningful? I'm not sure, but certainly the government's public relations stance in Nova Scotia has been, they keep on repeating, 3 sets of negotiations, 3 tentative agreements. We have discharged our duty to bargain in good faith and have meaningful consultation. Do you want to comment on that, panelists?
Well, I guess there are a number of dimensions. I think you raise critical issues, Larry. In terms of the Meredith kind of discussion, clearly this was an across-the-board public sector attempt to maintain the so-called sustainability of the public service. So the teachers were not being singled out on the wage stuff, right? And the other aspect of the legislation, I think, is that it does, in terms of this Commission on Inclusive Classrooms and the Council to Improve Classroom Conditions, there are legislative mechanisms to address the issues which were perceived publicly to be the most significant in addition to the wage issues. So where that takes us, it's not, is that consultation now finding itself embodied in legislation? I don't know how a court would characterize it.
Yeah, I think that's right, and I'll jump in and say, like, in that case, and I'm not as familiar with it as you are, but on the outside, sort of looking in, it may have had all the trappings of consultation, because you know, as you said, it went through 3 rounds. But in the BC case, which is now, you know, the ruling of the Supreme Court of Canada, is that consultations are just one contextual factor. It can't answer it in and of itself, and that was very clear from the majority of the Court of Appeal, which was agreed to by Justice Donald and then endorsed by the Supreme Court of Canada. In addition to that, I guess the question is, were the consultations meaningful? Because to what extent was the government setting the parameters from the outset, and did that limit, as in the Bill 115 case, sufficiently limit the talks that they couldn't have been meaningful? And of course, they were being conducted under the threat of legislation. So that's something to be taken into consideration. And then I think the final thing, and I'm probably missing a bunch because I'm not as aware of it, but they didn't impose the last offer. They opposed back to like the first offer. And is that in good faith? I guess I would question that. And so those are the kinds of things that I think you know, the court is going to have to grapple with.
Yeah, I would agree. Those are the issues that are going to be front and center.
Just to head down, I'm just looking to see if there are hands up. Geez, we have a very silent group of participants. But oh, I see Miles Ellis has his hand up. So Miles, I am unmuting you. Go ahead.
Good afternoon, folks. Hi, Diane.
Hi.
I'm with the Canadian Teachers Federation. And hi, Professor Archibald.
Hi there.
I'm fascinated by your comments. I'm thinking of something a little even more recent than what you're talking about. I'm thinking about recent legislation in Saskatchewan and in Manitoba, where it seems that very similar things are happening with regards to wage restraints imposed in advance without consultation by the government. They're not exactly the same, but certainly in Saskatchewan, you know, as far as education goes, it seems to me like 3.5% rollback, and here elected trustees find a way to do it. And then in Manitoba, 0, 0.75, and 1 going forward from existing collective agreements for teachers, at least, if not all the public sector. I would be interested in your comments on similarities and differences between Nova Scotia situation and even BC Health.
Well, I have one reaction to that, and that the fact that the Public Services Sustainability Act in Nova Scotia has never been proclaimed is an interesting phenomenon, in the sense that the negotiations are still going on with the NSGEU, the general, the largest public sector union. And so the government, I assume, will say, we passed this legislation, we indicated our preference in terms of our financial plan, but we did not proclaim it because we were involved in negotiation. So and is that a good thing or a bad thing from a constitutional point of view? It seems to me that they're trying to set up an argument which might counter Diane's argument and what was said in British Columbia, that the die had been cast. Well, here it's cast, but it hasn't landed yet, right? It's still up in the air because the legislation hasn't been proclaimed, but it was enough to get deals with other public sector workers, but whether or not it will stand constitutional scrutiny, obviously, is a big question.
Yeah, and I just might add, I don't know enough about what's going on in Saskatchewan and Manitoba, but I will say that these cases are difficult. They're going to have to get into real detail. There's going to have to be a lot of evidence called. In our case, we had 29 days of evidence on, and most of that was on whether the consultations were in good faith. There was some evidence on other issues, but in the second case, that's what the key issue was. And so it's hard from this level to say, you know, what the courts are going to do with that, but you're going to have to look at all those different issues and determine, as Professor Archibald has said, what was the die cast? And as I say, you have to back up a bit and say that consultations are just one issue. You still have to go back to the health services test and look at whether the legislation or the conduct has undermined the essential integrity of collective bargaining. That's really the bottom line. And but I think we're going to have a few more of these cases go forward, because right now we've got you know, unions saying that you can't really rely on consultations, and governments clearly believing that they can.
Okay, I'm gonna try and sneak in one more question here from Bob Hebden. Bob, go ahead.
Can you hear me?
Yes.
Oh, good. Yeah, I'm thinking back on this question of consultation, and is consultation actually collective bargaining? I'm thinking it as more of a practitioner who remembers a time when there was no collective bargaining in the public sector in Ontario, and at least in the civil service part of it. I was there, and what the union did was submit briefs every year. The government consulted, they listened to the brief, and then they did what they were going to do anyway. That's why collective bargaining came in, because that process was completely unsatisfactory and completely one-sided. In fact, in one of the historical examinations of this period, it was called the Consultation Model. And it was a model of consultation. They gave us notice of when things were going to happen, and then they happened. And public employees had virtually no involvement in that process whatsoever. So that, collective bargaining to me is a significant movement away from just the consultation process. I don't see how, maybe I haven't read all of the decisions, but I read a couple of them. I don't see how consultation by itself can satisfy some kind of definition of collective bargaining. It just doesn't seem to be compatible. It's either collective bargaining or it isn't, and governments know how to consult very well. They're very good at that. They come in and they've made their decision already, but they go through this motion of giving you notice that things are going to happen, and that's consultation. Well,
okay, Bob, I'm gonna cut you off and let both of our panelists answer very quickly. But before I do, I've got a new slide up here, just giving you a bit of more information on CIRA. Rather than having an extensive goodbye, we'll cut off a little after the hour. Bruce, well, I'll let Diane go first here.
Sure. I'll jump in. Well, I encourage everyone to read the dissent in the BC teachers case, the dissent at the Court of Appeal, because it really does sort of grapple with this issue of consultation in a way that other cases haven't to date. And as I already said, it's one of many factors that the court needs to consider. But also it's interesting that Justice Donald sort of says that you need the right to strike in order to have meaningful consultations. And, he talks about this in a number of different paragraphs, and I'll give them to you. In 287, 291, 296, as well as others, he's really talking about this approximate equality and referring to Justice Abella. So I think the real question is, what do consultations look like, and when will they be relevant? I mean, do they need to have some sort of dispute mechanism at the point of impasse? Because under a consultative model that we were just talking about, or the question was, is that's assuming there is no recourse for employees when negotiations break down.
Bruce?
Yeah,
Briefly?
and I think that that's critical. Is there clearly in Nova Scotia, the legislation says that arbitration is not the answer. That's not what I read the Saskatchewan Federation of Labor case to say, and it's not, by the sound of it, what the dissent in the BC teachers case says, in the Court of Appeal. So, I think you could say that there was a lot of bargaining, and that maybe was better than consultation on the inclusion questions and the classroom conditions and so on. But it's hard to see where there was any consultation on the 0, 0, 1, and 2. That was just proclaimed by the government.
And 1/2.
And
they proposed an agreement that gives them 0.5% right at the end of the 4th year. Not that
that's
it's
right.
important.
The last 2 is in fact 1.5 plus 0.5.
Yeah.
Right.
Okay, thank you, folks. This was wonderful. I must add that we are recording this, and if everything works the way I hope, we will, the Canadian Industrial Relations Association will be posting it because I'm sure that many of you and your friends who weren't participating would like to pick through the entrails of this discussion. Thank you so much, Bruce. Thank you so much, Diane. Bye-bye, folks.
Thank you. Bye now.
Thanks. Bye-bye.